attendees will be joining us throughout the hour. My name is Carrie Naoni, and I'm the Executive Director here at TIE Oregon. Thank you all for joining us for the fourth of several webinars that we've been producing to explore how to survive the COVID-19 pandemic. We do have a really great panel lined up for you today, but I'd like to first thank our sponsors that you can see on the screen. These folks support TIE, so if you are looking for any type of service, please take note and support those who support us. A few housekeeping items. This webinar is being recorded, so you can reference it later or forward it on to your colleagues and clients. Please make sure that your phone is muted. We will be taking questions via the chat box, and we will try to get to as many questions as possible. This webinar is going to be 60 minutes long. And now I'd like to turn it over to our moderator. She's a TIE Oregon board member and is currently the principal at 360 Advisory, Anna Shad. Anna?
Hi, everybody. Thank you for having me here. And I am being joined by three powerhouse attorneys that are going to help us figure it out. I mean, it's been about almost 4 weeks that we've been into the stay home, stay safe order and how things have actually affected businesses, still affecting businesses, and then there's still a lot of confusion, I think, with a lot of the things that are going on to help businesses. So I feel like we have a really good curation of questions to help us understand. So I have a list of questions here. We're going to be taking questions, but we're going to start out a little bit just taking maybe an intro from the three attorneys that are going to be in the panel, and then we can jump right in. So I'm going to go in order in my screen. So Ben, you are on top there. Would you just start?
Great. Well, hello, everybody, and thanks for your attendance here today. My name is Ben Stafford. I'm the partner at Perkins Coie in our labor and employment group. I'm actually based out of our Seattle office, but work very closely with a large number of Oregon employers with folks in our Portland office. My practice runs the gamut of labor and employment, including a lot of guidance and counseling around employee and employer policies and procedures, day-to-day counseling on issues related to leave, wage and hour laws, etc. I actually also work on wage hour class action, work on the litigation side of the fence.
Well, thank you. And Misha?
Hi there, my name is Misha Isaac. I am a partner at Perkins Coie and actually am Perkins Coie's newest partner because up until about 6 weeks ago, I was general counsel to Governor Kate Brown. I was a lawyer in the governor's office for 5 years since the beginning of the Brown administration. And Perkins Coie then recently recruited me away to come be a partner at Perkins. I primarily focus on litigation, both at the trial level and appeals. But, recently, obviously, the state has been having a pretty significant impact on businesses and individuals. And so I'm also working to help folks navigate the current situation, particularly given my knowledge and expertise about Governor Brown's office, executive orders, and how the state generally functions. So thank you for having me today.
Thank you. And then Ferdy?
Hello, everyone. My name is Ferdy Ruplin. I am a business attorney at Tongan Torp. I help our clients with all different types of corporate transactions, corporate governance, mergers and acquisitions, and I do a fair amount of work with our cannabis clients with regulatory compliance matters.
Cool. Thank you all. So basically, you can see we're gonna try to cover the whole gamut from the executive orders, but like employment questions and small business questions. So I want to start out with Misha and the way the executive orders from Governor Brown's. And guys, I'm sorry about my accent here because I know if you don't understand anything I'm saying, just let me know. Okay, just go like that. But because I sometimes don't understand myself. But anyway, so I think, Misha, we're curious on how these executive orders are restricting the businesses in Oregon, right? How do they restrict the different types of businesses, like the retail versus non-retail and property management? Can you help us understand a little bit of that?
Sure. Yeah, thanks for that question. So there are many folks in Oregon who really haven't had a need to focus on the governor's executive orders until now, because usually the governor's executive orders are just directives, management directives to state agencies. And so now, really, for the first time in memory, the governor is using her emergency powers through executive orders quite expansively to regulate the private sector and individuals. So let me talk. So the governor has issued, I think, 17 or 18 executive orders in the last 5 weeks or so. And I'm not going to talk about all of them today, but let me talk first about probably the most significant and impactful in all of our lives, and that is Executive Order 20-12, which is the so-called Stay Home, Save Lives executive order. Now, this executive order is important and notable, first of all, because, as I said, the significant impact it has on all of our lives, but second of all, how dramatically mischaracterized I think it has been in the local media. And so I'll just walk through briefly what the executive order does, and then talk about what the executive order doesn't do, contrary to what perhaps you've read in some local news outlets or seen on TV. So what does it do? First of all, the executive order requires the closure of certain specific types of businesses, and this portion of the executive order is quite limited. The types of businesses that it lists are things like amusement parks, aquariums, arcades, hair salons, bowling alleys. I mean, they're not the kind of business that we normally would interact with on a day-to-day basis, but they are the kinds of businesses that Governor Brown determined simply just cannot operate by applying social distancing protocols. With respect to the vast majority of retail businesses that are not in this very specific list, the executive order says that those businesses can stay open if they maintain social distancing protocols. And so, I mean, you may have noticed if you're driving around town, there are hardware stores that are open. There's all kinds of retail establishments that are open, and that is totally permissible under the executive order as long as these stores are applying social distancing protocols. Now, this portion of the executive order specifically exempts out grocery and healthcare establishments. Those operate in a different arena and are not affected by this executive order. With respect to non-retail businesses, so the kind of businesses that many of us work in, the executive order says that those businesses must allow working from home to the maximum extent possible, but at least those businesses, to the extent working from home isn't possible, those businesses must apply social distancing protocols. So again, contrary to what perhaps you've read in the newspaper, those businesses are not required to close. They're not required to have everybody working from home because social distancing protocols are allowed. Finally, I'll mention that executive order 20 for instance, when engaging in recreation or patronizing businesses, the executive order requires that we must maintain social distancing with people outside of our immediate families. So let me just mention a couple of things that this executive order doesn't do, and a couple of ways in which this executive order has been misunderstood or dramatically misrepresented in the local media. First of all, notwithstanding the name of this executive order, it does not require anybody to stay at home. Nobody is required to stay in their house under any circumstances, and this executive order has no mandate to that effect whatsoever. So I've heard this executive order referred to as the stay-at-home order or the shelter-in-place order. That is a complete mischaracterization of what the legal effect of the order is. Second of all, the only types of businesses that this executive order categorically closes are the listed ones that I mentioned, things like bowling alleys and hair salons. With respect to the vast majority of businesses, both retail and non-retail businesses in the state, this executive order allows those businesses to stay open as long as they adhere to social distancing protocols. The other main way in which this executive order has been misrepresented in the local media and conversation I've heard about it has been sort of in error, is that the governor has not distinguished between so-called essential and non-essential businesses. I think I read in the Willamette Week last week that Governor Brown declared that marijuana establishments were essential businesses. That is completely false. There have been no determinations by the governor of Oregon that some businesses are essential and some are non-essential. Those categories have been used by other governors in other states, but not in Oregon. So if you're driving down the street and you're wondering, well, why is this particular type of business open? That can't possibly be an essential business. Well, that's because it's permitted to be open under the governor's executive orders. So I know I went on long there. There are more executive orders to talk about, and I'm happy to talk about those as well. But that's really, I think, the most impactful on our businesses and our day-to-day lives.
Okay, well, yes, and okay, this is actually clarified a lot. That said, though, it's still, I think that the orders put a burden on the businesses, and some of these businesses are actually closed indefinitely. You can even see that. And the U.S. and Oregon constitutions require the government to compensate business and individuals when its actions constitute takings. Are some or all these executive orders considered takings?
Yeah, that's a really good question and a very interesting question that I think that we're likely to see litigation about, if not in Oregon, then national litigation about, because governors across the country have issued orders like this. So just to frame up this issue so that make sure everybody understands it, as you just heard, the U.S. and Oregon constitutions permit the government to take private property for public purposes as long as the government compensates the property owner for the so-called taking. The kind of taking that you're probably familiar about and have read about in the paper is that's pretty common is if the government wants to build a state highway through your property, the government can seize your property and build a highway through your property or public building or what have you, as long as the government compensates you for that taking. Now, what I just described is known as a physical taking. The courts also talk about something called regulatory takings. What a regulatory taking is that's when the government doesn't actually physically seize property, but it regulates property to such a burdensome extent that it basically renders the property valueless or significantly diminishes the value of the property. And so basically the question being asked is, look, if the governor has ordered the closure of my business or has imposed a significant financial burden on my business, does that constitute a regulatory taking for which I have to be compensated by the government, by the state government for? I think in most cases, the answer to that question is going to be no. And the reason for that is because the way the Oregon courts have talked about regulatory takings, they basically ask the question, does the landowner retain some substantial beneficial use of the property or some economically viable use of the property despite the regulation? So one of the leading cases in Oregon was about, an endangered species protection regulation. There was a property where the landowner was using the property for logging purposes, and because of the presence of the endangered species, the landowner could not log most of the property. Something like 85 or 90% of it was non-loggable because of the endangered species regulation. The Oregon Supreme Court said, no, that's not a regulatory taking because you can still log the remaining 10 or 15% of the property. In other words, you do still retain some substantial beneficial use of that property or some economically viable use to that property. So again, I mean, for most businesses, the entire usefulness of your business or economic viability of your business is not done away with as a result of the governor's regulations. The reason why I'm talking in terms of most businesses, and I'm equivocating by using language like probably, is because there are some businesses that the governor has ordered to close, or the governor has basically made it so the business cannot effectively function because of the social distancing rules, and some of those businesses are going to go under. Some of them already have. Some of them will probably go out of business in the next month or two here. And with respect to those businesses, yeah, I think that there is a real substantial question about whether there's a regulatory taking there, and whether the state is going to have to compensate those businesses. And, you know, some of those issues are going to be litigated, and we're going to see how that comes out.
Okay, well, this is what I'm going to do, a little quick segue then on the government programs that have been put in place. And this is going to go to Fergie actually on, you know, obviously there's the two big, the PPP and the EIDL. And I'm curious, and as we ran out, we heard last week on one for PPP sort of just ran out, and I'm curious to hear what your thoughts are on the current program, and you know, what do you think is going to have a fund to, and can you just give us a little bit of an idea?
Sure. Yeah, so Congress initially allocated $300 billion to the SBA to carry out the PPP and the EIDL programs. And kind of as expected, the funding ran out just about a week and a half after the PPP program initially opened. I know that Congress is currently working on a deal to allocate another $300 billion in funding, with $250 billion going to the PPP program and $50 billion going to the EIDL program. You know, I think that the programs will essentially be the same. So they'll likely use the same application, be governed by the same terms, but I think the government just wants to get additional funding to the program to get more businesses access to it.
Okay, can you give us just a quick recap for people who don't remember, for the PPP, what the forgiveness provisions are? Because I have a question after that, so.
Sure. So I'll start by saying that the SBA has stated that they will come out with additional guidance on the loan forgiveness provisions, which I think is very much needed. There are a lot of unanswered questions at this point, and you know, I think everybody is looking for further clarification. But to give a general overview, any borrower that receives a PPP loan is entitled to loan forgiveness for costs incurred and payments made on payroll costs, rent and mortgage obligations, and utility payments that are incurred in the 8-week period after the date that the loan funds are dispersed. You know, I think it's important for businesses to remember that 75% of the amount of loan forgiveness has to be attributed to payroll costs, and only 25% can be attributed to rent, mortgage, and utility payments. You know, I think it's also important for businesses that have received a PPP loan to start thinking about the loan forgiveness provisions now. You know, it's not automatically given. It's something that you have to apply for with your lender. So you'll want to make sure that you keep receipts and documentation for all expenses that are made with the loan funds during this 8-week period, because you'll need to submit some backup documentation to the lender when time comes to apply for forgiveness.
That's actually a good question. There was a question about that. Do you think the employers need to keep a separate bank account for when, or just the receipts would be enough?
I definitely think it's a good idea to segregate the funding if you can. You know, I think it's definitely advisable to have a separate account. I think it makes things easier. You know, again, we don't know what the application process looks like yet for loan forgiveness, but you know, doing everything that you can right now to get yourself in the best position, I think it's a good idea.
Okay, and one question I get asked a lot, when you say payroll costs, 75% has to go just to payroll costs. Do benefits count towards this? If you pay health insurance and 401k costs, are those counted as payroll or not?
Yes, they are.
They are?
Yes, they are. The CARES Act defines payroll costs as essentially the salary and wages, and then other ancillary benefits like group health insurance and retirement benefits.
Cool. So I just want to, there was a question that I think it's been the big thing, which now combines what Misha said with what you said. Some businesses are not allowed to open, obviously, but the 8 weeks time starts from disbursement of the loan. And as we know, there are a lot of employers that got funded or are going to get funded, but they don't have a business to run, so they can pay payroll. So now they don't have a time to open, but they are on the clock to convert. So if they don't use that money in payroll, now they don't have anybody to pay because their business is not open. Do you see the cyclical? Do you feel like, is that a solution for that right now that you think they can do, or they just have to deal with what's going to come?
I think, unfortunately, there isn't a solution. If we take a step back, you know, the CARES Act and the PPP loan program, the purpose of it is really to inject funding to businesses to keep paying employees. So I think the idea is that businesses that receive a PPP loan will continue paying employees even if they're not operational, so to avoid having those employees being laid off and having to file for unemployment.
Okay. Ben, I'm going to ask you a couple questions on labor and employment, only because there's so much happening right now. And one, it's funny, I just got this morning, Ferdy, exactly related what you said. There are some clients that are trying to do that with PPP, but some employees are actually making more money in unemployment with the $600. And it's difficult for employers to know what's best, right? But
Right.
We know that there has been these competitions between furloughs and layoffs, and there's a lot of confusion. So I was going to ask Ben, Ben, when an employer makes a decision to furlough employees, right, can the furloughed employee look for a job somewhere else while they're furloughed? I mean, we know they can't apply for unemployment, but can they look for a job, or are they technically still employed? They can't.
So a lot of different moving pieces for that issue. So layoff, somebody is formally separated for at least some period of time, you know, their employment is over. A furlough is basically used in a few different ways, but I think of a furlough as essentially an unpaid leave of absence. So you are not laid off, you are furloughed, you are sitting on the sidelines, not actively working. And you can have partial furloughs or full furloughs, but normally people use that as a full furlough. Mm-hmm. So yes, an employee can actively look for work during a period of time where you say, okay, we're furloughed for 4 weeks. We hope to bring everybody back in 4 weeks when conditions improve, when Governor Brown's orders end, whatever it may be. And during that period of time, somebody would be perfectly free to look for other work. However, one, think about what your other policies and agreements say. Do you have anti-moonlighting restrictions? And do you want to make sure that those are lifted in this particular circumstance? Do you have non-compete obligations that employees have that would restrict where they could be looking for other work? Do you have confidentiality concerns given where else they may find employment? And the employee on their own side may want to think about the impact on unemployment. It's quite possible that an employee who's been furloughed is going to qualify for unemployment. However, if they get another job, then of course that's going to have an impact on their unemployment. But you may actually be eligible for unemployment. And then the final consideration is going to be healthcare. So what is the impact of being furloughed on your healthcare benefits? And that's going to be a function of what your plan says. But generally speaking, at a certain point for a certain length of unpaid absence, then the employee is no longer going to be eligible for health insurance. They're going to have a qualifying event. They're going to have to sign up for COBRA. So all of these things come into play in terms of whether an employee can work somewhere else while they're on furlough. So short answer is yes, but there's a lot that comes with that.
Okay, well, this brings up a good discussion about the whole, the benefits and all. So do employers have a time limit to bring these furloughed employees back, or to let them know? Is there like any sort of, you know what I mean, or they just stay there and, you know, waiting to, you know what I mean, to get, you know what I mean? Like, what's the protocol there?
Yeah, absolutely. So there can be Implication. So the short answer is no, there's no specific time limit, but there's a lot of implications that come with it. An indefinite furlough is likely to be viewed as a layoff by the government for various purposes, such as unemployment. A short enough duration of a furlough may mean that somebody can stay on your health insurance benefits without opting for COBRA, where they have to pay at their own expense. A short enough furlough may excuse the employee from some of the unemployment obligations. So for example, in Oregon, if you have a short enough furlough, the employee normally has to show that they're actively looking for other work to get unemployment benefits. But if they have a furlough of 2 weeks, they don't have to actively look for employment. They have a job lined up. It's just going to be starting again in 2 weeks, right?
Yeah.
And then the other consideration is around the Federal WARN Act. So if you are a large enough employer where you are subject to the WARN Act, stated briefly 100 or more employees, just to keep things simple, although it's more complex than that. Then if you have somebody furloughed for 6 months or longer, then you are triggering WARN Act notice obligations, where it's like if you have a mass layoff, you have to let people know that they're being laid off 60 days in advance, and you have to tell the government, and there's a variety of rules and implications. A furlough of 6 months or more might implicate that. So there's no strict time limit, but in thinking through what makes sense for the business, for the time limit, you're of course trying to retain the employees that you don't want to leave and go somewhere else, and you're thinking through the implications on various benefits on various programs, given what the duration of the furlough is.
Okay, I just want to clarify that answer because again, I understand the WARN Act for larger employers, but let's think Portland, small employers, a lot of those people had to close, they furloughed, they didn't know, but they also don't know when they're going to open. So let's talk about, restaurants or retail. Do they have a legal obligation to reach out to the employees to give them a state, or they can just continue on until they know what's going to happen? I mean, are they going to get in trouble if they don't get back to the employees?
Sure. No strict you violated X law because you didn't update people. But what I would generally say and advise to employers who are in that circumstance is you say, okay, everybody's on furlough until May 4th. And then, we're continuing to closely monitor this fast moving situation. And then you get closer to May 4th and you're like, well, the state's not open yet. We have, our supply chain is down, whatever it is. We are either going to convert the furlough to a layoff at this point, or we are going to extend the furlough until May 21st. We will keep you advised as we monitor this fast-moving situation.
Okay.
Is the way that I would go about that.
Okay. I do have a question here that I'm going to ask you for real quick, and then we'll kind of go back. But Kelsey is asking us here, what's being done to ensure companies who received PPP cannot also dip into unemployment benefits or payouts? And she says, those of us who attempted to apply, got the runaround and lost, and now struggle to receive unemployment, they would be aggravated to know that someone is double dipping when they, that we cannot even find help. Have you heard of anybody that's double dipping?
I have not personally heard of any businesses that are double dipping, but I imagine that it will be very, very difficult for the government to keep track of that. I mean, I know the SBA is completely overloaded with the number of applications they're getting for PPP loans. And I know the government that's handling the unemployment insurance is also completely overwhelmed. So I don't know. I haven't heard of any coordination to figure out if anybody's double dipping, but that's a great point.
Okay, thank you. Hey, Misha, I have a question for you. So these, going back to the executive orders, thank you for being our expert on this. These orders from Governor Brown have been the most sweeping use of any Oregon governor's executive powers in memory. Are these lawful, and are they vulnerable legal challenges?
Yeah, so that's an excellent question, and I think honestly it remains to be seen. You're absolutely right that no Oregon governor in recent memory, and I'm not sure ever, has exercised as sweeping executive powers as Governor Brown has in the last 6 weeks. I don't say that with any judgment about it. I mean, obviously we are in an unprecedented crisis here, and I think the governor is doing the very best that she can. But it's absolutely true that the executive order power by the governor is most often used to, direct and oversee state agencies. And in the last 6 weeks, Governor Brown has used these executive orders pursuant to her statutory emergency powers, not just to direct and oversee state agencies, but really to establish law regulating private individuals and entities. And in fact, if you look at all of the governor's executive orders, she quotes and repeats a sentence from Oregon statutes that basically say this executive order has the status of law. And speaking as a lawyer, it is something quite remarkable that, ordinarily when we enact laws, the laws require a significant amount of vetting through the legislative process. They have to pass out of committees, and that obviously pass off of out of both chambers of the state legislature, go to the governor for signature. And there's a lot of barriers to entry, I'll say, to get an idea to become a law ordinarily. Today the governor is purporting to make law just unilaterally, and that is something quite significant. In terms of, if there were legal challenges to these uses of the governor's sweeping uses of the governor's executive powers, what would those challenges be? Well, I can think of a few. First of all, the governor's emergency powers are listed in ORS Chapter 401. And if you go and you can Google ORS Chapter 401 and you can read it, almost all of the governor's emergency powers are focused on the commandeering of public resources to respond to an emergency like a natural disaster. And so you can imagine when the legislature is drafting ORS Chapter 401, what they have in mind is that there's going to be some, for instance, Cascadia style very significant earthquake that would cause, a massive death in the state or something like that. The governor would declare an emergency, and the statute contemplates that the governor can commandeer all of the public resources in the state. So local fire departments, local state police, to respond to that kind of natural disaster. That is the sort of thing that the Declaration of Emergency statute in Oregon is focused on. There is very little authority in that statute for a governor's direct regulation of private individuals and entities. And that's really what sets this set of executive orders apart from the way the executive order power has been used in the past. That, the governor is not just ordering businesses to close, but she's regulating, whether landlords can evict their tenants.
Mhm.
And, you look in that executive order statute and wonder, where is that type of action authorized in the statute? And on and on and on in terms of the governor's sweeping uses of her executive authorities. So in addition to the statutory question, there are some important constitutional questions here, including whether the legislature's delegation of basically lawmaking authority to the governor through ORS Chapter 401 is a constitutional delegation of legislative power. I think that is an open question we're going to see litigation about. And there's also the takings question, that I discussed a few moments ago. I think all of those are significant and open questions, and there may well be litigation about them in Oregon, and I expect there certainly will be litigation about them somewhere, if not here at home.
So one other question for you is, obviously this downturn is going to prevent businesses and individuals from paying their financial obligations. I mean, we know that she put a moratorium on, owners and landlords, and that's put them on in a particular tough spot, as we know. But there's a two-part questions. Number one is, how can these owners and landlords stay solvent, you know, when they're not required to pay rent, but they can also not, you know, evict? That's one question, one part of the question. But the second question is, will the courts excuse these obligations, you think, in light of what's happening? Do you think the courts would have some leniency towards it?
Yeah, both really important questions. So first of all, I have to say, the governor's eviction moratorium orders, and she's issued 2 of them. They do kind of, I don't know if it's overstating it to say that they pick winners and losers, but I think that it's fair to say that the governor has made some policy choices about how to allocate the burdens of this current economic crisis. And the governor has basically decided to put a more significant burden on property owners and landlords. By that, I mean, the governor has taken away the main enforcement tool that landlords have, at least temporarily, and that is the eviction tool. The governor's executive order 20-13 says that both residential and commercial landlords cannot evict tenants and cannot take steps toward evicting tenants. And yet, you know, landlords and property owners have their own financial obligations, right? And so I have spoken with several landowners and property landlords and property owners who are saying, look, if I don't have rent coming in, it's not like I just have, you know, a huge bank account with which to pay my financial obligations. I have mortgages that I owe, or there are lenders who I owe money to, and I use my rent to pay those financial obligations. The governor has not relieved me of those obligations, and that's right. She hasn't. So there are a couple things that I would say about that. One is, you know, I suspect that the governor's office is thinking through whether there is a further executive order that's necessary to lighten that burden that's been put on landlords. And so if you you know, have the ability to communicate with the governor's office on that topic, you know, I think that kind of communication would be welcomed. The other thing to know, and I think it's important to remember about, you know, if you're a landlord or a property owner, about the governor's executive order is, and again, this has been, the reporting on this hasn't been great in the local media, but the executive orders specifically say that tenants continue to have a rent payment obligation, right? So the executive orders do not relieve tenants of paying rent. They just take away landlord's enforcement tool, and that is eviction. And so if you have tenants who are not paying rent, it's important to stay in communication with those tenants. You know, think about payment plans, think about, you know, retaining good faith with tenants by having them pay what they can now, and perhaps negotiating through some reconciliation, you know, relieving some of that rent obligation for the tenant so that you continue to have that stream of income as a landlord. So that's the first part of the question that you've asked. The second part of the question is, of course, a broader question than just the you know, residential landlord-tenant relationship, and that is, you know, there are a lot of people in our economy, because of the precipitous economic downturn, who are suddenly finding themselves in a position where they've made payment commitments or other contractual commitments, and they are finding that that they just can't discharge those commitments. They can't pay those obligations or what have you. And the question you asked was, you know, are courts going to relieve folks of, or excuse folks of, these payment or other contractual obligations in light of this totally unforeseeable economic crisis that we've had? That is a really complicated question. I think we're going to be in the legal arena, we're going to be hearing a lot about this Latin term, force majeure. Force majeure is a legal doctrine that is a defense to non-performance of contracts. The Latin term literally means superior force, and it ordinarily contemplates things like acts of God, death or disability, war, or some kind of a supervening illegality. But there's also an offshoot of that legal doctrine that are the defenses of impossibility and impracticability. Basically, the Oregon Supreme Court and state Supreme Courts around the country have recognized that there are certain extreme circumstances that are unforeseeable, unforeseen when agreeing to a contract that can arise, that can sort of fundamentally undermine the bargain that was entered into in the contract. And so in these extraordinary cases, and for some people, you know, this current COVID crisis may be such an extraordinary case, courts will excuse performance of contractual obligations. So let me just say the analysis of those force majeure, impossibility, impracticability questions are highly fact specific. So it's impossible for me to, you know, make a prediction here in general terms about how courts will resolve all of these issues. But I will make a prediction, and that is we're going to see a lot of this force majeure, impossibility, impracticability litigation over the next few months or years. And I think that these cases will turn on the following three factors. First of all, does your contract that creates your payment obligation or your performance obligation, does that have a force majeure term in it? If it does, the courts are going to look at that term to try to see, well, what do the parties have in mind in terms of whether this kind of situation would be a defense? The second consideration is, you know, how precise is the causal link between the intervening event and your non-performance or non-payment? So for instance, you might have a personal service contract, like a contract to build a house, for instance, where the contractor himself got personally ill or even died as a result of COVID-19, right? In that case, there is a very precise causal link between this intervening event, the illness, and the non-performance. But for most of us, it's going to be inability to perform because of just generally the economic conditions, the economic downturn. And I think courts are going to be really reluctant to say, well, okay, there was an economic downturn, we didn't expect it, and so you're relieved of your performance or your payment obligation. Finally, courts are going to look to the foreseeability of the intervening event. And so, like, consider the foreseeability that we would have, like, a sudden virus would emerge that would create this international pandemic, right? Probably not the most foreseeable thing, versus an economic downturn, which, while we certainly didn't expect the economic downturn right now, and we certainly didn't expect that it would be quite this sudden and precipitous, we all expected that there would be an economic downturn in the next few years. I mean, economies are cyclical. So courts are going to be reluctant to relieve people of their contractual obligations just by virtue of that.
Okay, well, thank you. I appreciate that. I want to change just a little bit towards the whole piece of the CARES Act and talk to Ben a little bit about that. We have a question here, and then Ben, you know, we talked about furloughed and laid off employees, but they're now the employees that didn't, you know, they're still working and now are being protected by the CARES Act. And are you able to explain a little bit what that entails in terms of FMLA and paid sick time and all that? And also let us know, does that apply for both exempt and non-exempt employees?
Sure. So these rules apply to all employees, full-time, part-time, exempt, non-exempt. If they're part-time, then you basically do things on a pro rata basis. So there's the CARES Act. There's also some modifications that have been made to state law. For example, it's now clear that under Oregon's OFLA, Oregon Family Leave Act, if you need to care for a kid who's home because their school has been closed by executive order, you can use OFLA leave for that. All the same eligibility requirements apply. With regard to the new CARES Act leave, there's two new forms of leave. There's expanded sick leave, and there is expanded FMLA leave. So you got to break them into the two buckets. For expanded sick leave, people are eligible right away. You get basically up to 2 weeks, 80 hours over a 2-week period for a full-time employee for certain kinds of absences due to being sick, caring for other people, being under a quarantine order, etc. There's certain eligibility requirements that are set out. And that's paid up to a cap that is set out, and it depends on the specific form of why you're out. For a part-time employee, you look at the average number of hours they work in a work week. So if you've got an employee, I'll give you an easy example. They've been there for a year. They always work 20 hours a week. Then they're going to be eligible for up to 40 hours of paid sick leave under this new program. They work 20 hours one week plus 20 hours the next week, on average 40 hours of sick leave, and so on and so forth. It's just a straight pro rata based on the employee's average number of hours they work in a given week. Then there is expanded FMLA. Now, normally, and again, the eligibility qualifications are more complicated than this, but if you don't have 50 or more employees overall, you're not worried about FMLA, except now you are under this expanded FMLA program. If you have fewer than 500 employees, this is true for the sick leave program as well. If you have fewer than 500 employees, this applies to you. Mm-hmm. There is a waiver if you have fewer than 50 employees that you can attempt to take advantage of. You basically have to have an authorized officer make a certain kind of determination that giving these forms of leave will end you as an ongoing concern. You don't submit that to anybody. You just make your own record of it and then hope that an employee doesn't challenge that. But that's the procedure that we have. Assuming that these rules do apply, you have fewer than 500 employees, you haven't made a determination, you're going to try to qualify for the small business exception, then what you need to do is for an employee who has worked at least 30 days, that's the eligibility requirement, it's 30 days for expanded FMLA. Then you need to provide leave that, again, is paid up to a cap for certain sorts of absences. An employee is subject to a quarantine order. They've been advised by a healthcare provider to self-quarantine. They are experiencing COVID-related symptoms and are seeking a medical diagnosis. They're caring for somebody who's in self-quarantine or has been advised to self-quarantine. You're caring for a kid whose school is closed. If you meet one of those criteria, then it is paid leave up to an additional 10 weeks beyond the sick leave, 12 weeks overall for these purposes, payment up to a cap. So again, lots of rules and moving pieces that I can clarify any of the things that I glossed over. So that's the overview.
Okay, so just to clarify, because we do have a question that actually ties into it. So the question is, if I'm hiring a new employee in May, do they immediately qualify for that sick time? And I'm assuming the question is for the expanded sick leave. I know they won't qualify for the expanded FMLA because they have to be 30 days, but they will qualify for the expanded sick leave right away.
Correct.
Okay. We had a question here and says, if an employer requires an employee to self-quarantine, would the employee be eligible for emergency paid sick leave? So I'm assuming the answer is yes on that, if they meet the criteria.
That's actually quite complicated. They might not. So if you're advising them to self-quarantine because they come to you and they say, I have a fever, then they're experiencing COVID-related symptoms and they're seeking a medical diagnosis. If, however, they say that they were exposed to a family member and we say, well, we want you to self-quarantine, then that alone does not qualify them for extended sick leave. However, it should be easy enough for them to talk to their medical provider if you were telling them to stay home and to have the medical provider advise them to self-quarantine, and then they would qualify. So in other words, it's almost certain that an employee would be able to figure out how to do what they need to do to qualify, but the mere fact of an employer saying, please self-quarantine would not qualify them for extended sick leave.
Interesting. Another question is, if someone contracts, COVID on the job, can they file workers' comp?
Yeah, potentially. I mean, in the same way where if they were exposed to another dangerous condition, that's a work-related injury or illness, and they might qualify. Now, can they prove that it was job related? Can they prove where they contracted it? There may be problems with proof. But in concept, yes, if they were exposed because of work to COVID, then likely that would indeed qualify them for workers' comp. Then, of course, you get very difficult issues when it comes to working at home, and probably if they're home and a family member has it, you're probably not on the hook for that. They didn't really contract that through work, even though they are working from home.
And I know that working from home is a whole other chapter, but I wanted to go to Ferdy a little bit and talk a little bit about a whole other area. There's so much to talk about, but Ferdy, I was trying to figure out a little bit, what is the current atmosphere for this is for like M&As, mergers and acquisitions, what's going on right now in that world? Are the transactions still taking place? Did people just stop? Do you have any sense of what's happening?
Yeah, it's been really interesting to see how things are changing over the past month or so. I know a lot of deals have fallen through. I think it really depends on the industry that the target company is in and the long-term viability of the business. I've seen a lot of cannabis transactions are moving forward, whereas target companies that are operating in spaces that have been badly hurt by the pandemic are seeming to fall through. So it's kind of all over the map, but there's definitely still some activity. I expect to see, distressed investments and investors who think they can get a good deal will definitely be interested in the future. But things are definitely changing.
They are. And do you see also a huge change right now with actual investment in startups? I mean, are you seeing like a lot of people, pumping the brakes with investments or not?
It's kind of the same thing. It really depends on the viability of the business. I've seen funding go through for startups tech startups that actually operate in travel planning software. Investors that think maybe they're getting a good deal right now are still willing to go forward. But again, it really depends on the business and whether or not the investor sees long-term value and whether they think the startup can kind of ride out this storm right now.
Mm-hmm. Okay, so here's what I want to ask Misha a question, and then I'm just going to invite the participants to put questions in. We're about maybe 7 minutes away, so I want to make sure that we answer all the questions. But there's one here that I'm interested. Misha, I think everyone right now is in that state where we want to do the right thing, but we don't know what the right thing is. And like I asked Ben, do we need to everybody's confused, right? So I guess, are there any litigation risks that you see that businesses can have? And are there things that you watch for this, watch for that? Is there anything you recommend to mitigate and minimize any litigation risks? Something that people need to know
Sure.
that you can think of?
Yeah, and just in term to your point about not knowing, wanting to act in good faith, but not knowing what to do. Yesterday, in anticipation of this webinar, I got an illicit haircut because I didn't want to look like, inmate or something in an asylum. So yeah, I think we're all in this situation of trying to do our best and act in good faith, and not under these extraordinary circumstances, and not knowing exactly exactly how to move forward with our lives and our businesses, etc. So you asked a very broad question, which is about mitigation of litigation risk. I talked a little bit about the force majeure, impossibility, and practicality issues. And if you are in a position where you cannot discharge a contractual obligation, or you can't pay an obligation that you entered into, certainly one way to mitigate litigation risk is to, consult with counsel about the particular obligation you have and whether you have a force majeure or impossibility and practicability defense. I'll just say one more thing in terms of mitigating risk. And here I am stepping on Ben's territory. But, having recently and for the last 5 years been an in-house counsel to basically the CEO of the largest employer in the state, the governor of the state of Oregon, we're going to see a lot of employment litigation coming up over the next few months and years because there is such a huge number of people who have been furloughed and laid off and reduced hours, et cetera. If you're an employer and you see in your future a prospect of, needing to take adverse action against your employees, the best way to mitigate your risk there is, building personal relationships and goodwill with your workforce. And I know that's strange advice coming from a lawyer, but really, making those personal connections with your employees. If your employees are working from home, calling them at home to check in. People are trying to do their jobs while also, homeschool their kids and provide childcare for their kids. Check in, how your parents, how your kids, how are you doing, how are you holding it up, how are you holding up? That can go a really long way in maintaining goodwill with your workforce and mitigating your risk of employment litigation.
Okay, well, there is an interesting question just came up, and it is, what's the liability and litigation risk from a customer being infected by COVID at the business? If there is a, doesn't make sense. I'm assuming it's the business they work, a customer being infected. Yeah.
Right. So it looks like the kind of situation I think I'm understanding from the question is like, I own a retail business that I've kept open. A customer comes into my business, is infected, and now has the potential to infect other customers, my employees, et cetera. Do I bear liability for that? And I think we're going to see some negligence claims arising from those situations as well. And so my advice to employers, and particularly where you have members of the public coming into your establishment, is that you are taking all required steps, but just all steps, conceivable or reasonable in order to protect your other customers and to protect your workforce. And so, that you're applying social distancing, if you can make masks available to customers who walk into your facility, make masks available, et cetera, so that you can show, if challenged, that you really took the reasonable steps that were necessary to protect your other customers and your employees. Ben, do you have other thoughts about that?
No, I think that's right. I mean, and so, and how are you treating your employees to mitigate the risk the employees get sick and then they infect the customer? And so I would just echo social distancing, PPE for employees to the degree that it's available and necessary and consistent with the guidelines, cleanliness of the store, if you have hand sanitizer available, if you're a grocery store, you're wiping down the carts. I mean, all of those sorts of things, so that you can point to all the reasonable steps and precautions that you took. And, if you're in a situation where, restrictions are being lifted and you are complying with the best government guidance that is out there, then that's the best defense you're going to have in those sorts of negligence claims.
Cool. Well, we're about a minute away, and I was wondering if there's anyone that has any final thoughts on this potential opening of the state. Anybody have any ideas they want to share? Are we opening or not? Anything?
Well, let me take the question that just came in. So the president has announced that he is issuing an executive order temporarily stopping immigration to the country. What effect would that have for people with work visas? And the answer, I mean, not to be flippant about this, is goodness knows, because as I understand, the text of an executive order has not yet been issued. And so is this a moratorium on the granting of new visas or people entering the country? Would it have an impact on people who are already here? Probably not. In terms of renewing visas, maybe, but what period of time would this order extend for? We just don't know the answer to those things yet, and what the follow through is from the administration on this issue.
Good, thank you. Okay, gosh, there's so much more to talk about. I wish we had another hour. I don't think we do. So, any other thoughts? Any final thoughts? Misha, Ferdy, no?
Well, I'll just add, and I'm sure that I speak for Ferdy and Ben to say that you know, if folks have questions specific to their situation and they you know, need to talk to a lawyer about that, you know, you can Google our names and reach out to any one of us. We're
Yes.
here in the client service business trying to help clients navigate this difficult situation, and so we're all three of us are happy to help.
And if you
Well,
need their contact information, I'd be happy to share it. This is Carrie.
yes, and then this is recorded, so you can go back and listen to it all over again, and then remember what the answers are, because there's a lot of good stuff that we got here today. So I appreciate you guys. Thank you very much for all this. And yeah.
Okay, I'll take it from here. Yeah, thank
Yes.
you guys. I mean, seriously, so much information. And again, as I've been saying, week after week, everything's coming so fast and furious. We're trying to continue to provide timely information every day at 12. So come back next week, and we'll have another dynamic topic for you all to enjoy. We do have another event this week, though, on the evening of April 22nd. I guess that's actually just tomorrow. It's out of our Thai Women's event series, and we've got a panel full of successful investors, entrepreneurs who are going to share best practices on demonstrating confidence in the pitch room. So please tune into that as well. It's going to be fantastic. As you can see, our panel is pretty awesome. Okay, the other thing, become a member of Thai. We do so many good things throughout the year. This is just one of them. We have a slew of programming, we have mentorship, we can connect you to investment sources. So please take a look at our website, oregon.thai.org. And we're also offering 6 months of free membership during this time, so take advantage. Now's a great time to try out membership and get more involved with Thai. Again, thank you to our support. Again, we could not do this without the folks on the screen. If you again need legal services or a bank or an accountant, please take a look at these folks who graciously support the Thai ecosystem. Okay, and with that, again, thank you so much, Ben, Anna, Misha, Ferdy. I really appreciate it. This recording will be up on our website probably by the end of the day. Thank you all so much. Bye-bye.
Thank you.
Thank you.
Thank you. Have a good one.